Hi everyone, and welcome to this session on term sheets. I'm Sarah Turner and I'm joined as usual by Angel Academe co-founder Simon Hopkins and our network manager Michelle McQueen. Simon may need to step in at some point. My internet hasn't been working very well this afternoon, but at the moment it looks okay. And of course we've got a brilliant speaker this evening, Emer Hughes from Kingsley Napley. The legal aspects of angel investment, any investment actually, are an important subject, both for the investors and entrepreneurs. As usual, to talk to us during this session this evening, please use chat. Have a think about your questions as we'll go along, and we will put them to Emer in due course. Just before we get going, a reminder about us. So Angel Academe exists to close the gender gap in startup investment. That's both the lack of investment going to female-founded businesses and the low number of women participating as angel investors. We've been doing this since 2014. In that time, we've backed 45 businesses, many through multiple rounds, so we have more experience than anyone else in female investment in the UK. The businesses we've backed have gone on to raise over £100 million between them from angels and VCs. They employ many hundreds of people in high quality jobs, and female founded startups tend to employ twice as many women in their businesses as male founded ones. They're also generating millions in revenues, and many have a social purpose at the heart of their mission, whether that be around diversity, better healthcare, lower environmental impact, etc. So Simon and I are both angel investors ourselves. We don't just run the network, we invest with it. When we started Angel Academe, we wanted to create an angel network that worked better for us as investors, where new investors could learn and would be supported in that learning journey, and where experienced investors could benefit from other perspectives, people from different backgrounds. And we also wanted to do thorough due diligence, but to save time by sharing the work. So we're a transparent network, very respectful of each other and founders that we see, and we're considered in our decision making. And the track record of consistently investing has created high quality deal flow for us. Just a little bit about what we look for in investment opportunities. Angel investors are very different from venture capitalists. We're investing our own money, so we have a little bit more flexibility than VCs who are typically investing other people's money. But saying that, we still want to back winners. We still need to see a return on our investment. Otherwise, we quickly run out of cash. But we don't need billion-dollar exits to make a good return. We're typically starting quite early, but we do want to see real ambition from founders, and the ambition to get at least to 100 million in valuation or more. So we're looking for founders who prioritize growth. They need to be comfortable giving up some control of their business to shareholders and everything that goes with that. And we want to exit within a decent time frame. So we need founders who are aligned with that as well. And we're particularly interested in innovative businesses, either tech or science-based. They tend to be more innovative, and also they create some barriers to entry for competitors. Right, well, that's enough about us. I'm absolutely delighted to introduce Emer Hughes this evening. So she's a senior associate at Kingsley Napley. Kingsley Napley and Emer have been advising us, as well as entrepreneurs, on startup investment since 2014. So it's been a very long and productive relationship. I have some questions for her to kick off the conversation, but we have plenty of time for your questions as well. So please put them in chat as we go along, and we'll make sure that Emer addresses them as well.
Hello, hi everyone. Hi Sarah.
Just quickly tell us a bit about yourself and Kingsley Napley before we start.
Yeah, sure. So Kingsley Napley is a law firm in London. We're a full service law firm. We have 13, I think it is at the moment, different departments. I work in the corporate commercial team. Within that, we do sort of general corporate M&A work, as you'd expect, but we also have a sub team that specialises in investment work, and that's either acting for startups when they're raising money or acting for investors when they're making investments. So that's either angel investors like some of the people listening today, or some family offices and smaller VCs. And I think typically for this type of market, most of the companies that we're either acting for or our clients are investing in tend to be tech companies or tech-enabled companies. And so, yeah, because we have acted on both sides, we sort of see both sides of the coin, and we think that gives us some good insight when we're advising our clients. And
you've seen quite a lot of our deals as well as they've gone along their journey.
Yeah, so we have. I think that's one of the advantages of being a sponsor of Angel Academe, is we can come along to all the pitch events, so we sort of see just what's happening in the market as well from that perspective.
Great. So quite a sort of high level question to start with. So what is it that we're trying to achieve with the legal documentation?
Yeah. Well, I mean, firstly, it's important that your investment is documented, and as angel investors in a business, you're probably going to be a small minority shareholder. So really, these documents are going to have some of the protections that you need as a minority investor in the business. Hopefully the investment's going to go smoothly. You can put these documents in a drawer and not have to look at them again, but they're there should you need them. It's important that if you do need them, you can look at these documents, and then it's got those protections that you need.
Brilliant. Okay, and what's the usual starting point for legal discussions?
Yeah, so I mean, I'll talk a bit later about all of the kind of legal documents you'd expect to see, but normally the starting point is obviously your heads of terms. So I'm sure kind of you've seen lots of heads of terms or sometimes called term sheets over the years. And really that's going to be, it's a non-binding document, sort of 3-4 pages long, and it sets out the key kind of commercial principles that are going to then go into the long form documents. And it's kind of easier and better for both parties to have that term sheet stage to be agreed on what the terms are going to be, rather than either side spending time and money preparing longer form documents until those heads are agreed. And that's the starting point for everyone.
Okay, and when does a term sheet come into play, and why is it so important?
Yeah, so I mean, in terms of timings, it can be very early on in the process. I mean, sometimes term sheets are agreed before due diligence has started, or really at the beginning of due diligence, and it is to set out those, because then that's what the lawyers are going to use to go away and prepare the long form documents. So it's typically done quite early in the process.
And in my experience, VCs tend to use them when VCs are involved as to buy themselves a period of exclusivity to do their due diligence, don't they? So
so some VCs will use it if they're planning on filling the whole round, will use it to kind of have exclusivity. Typically you don't tend to see exclusivity if it's in an earlier stage where there's a number of investors, because companies might have to go out and fill their round, but they still tend to be done quite early in the process. And I suppose that's the key difference as well, is who prepares your head. So if that could be the company as the starting point, or it could be a VC if they're leading around, or if, say, another angel network's leading around, it might be their term sheet that's sort of the starting point. So whenever you're looking at a term sheet as well, that's what's important. Think about who's prepared it and where it's come from, because that can influence some of the points that you'll look out for.
Mm. So term sheets or heads of terms are nice short documents and typically kind of include some key terms which we'll just see over and over again. Can you just run through those for us?
Yeah, and I'm gonna share my screen now, because and hopefully this will all go smoothly. Can you see that? Let's see, is that working?
Yes, yeah.
Super. Yeah, so in terms of kind of key terms to look out for in a term sheet, then first one is always, what are you getting in return for your investment? So what's the valuation of the company? So what's the share price going to be? And what are you going to be paying? And then, what are you receiving in return? So, what class of shares are you going to be getting, for example, and how many shares are you going to be getting? Typically at this stage, if you're investing and you're wanting that to be eligible for EIS and SEIS, then you're going to be investing for ordinary shares. So yeah, that's always the starting point. What's the valuation, and what type of shares are you getting? And then the other thing to think about as well is, if you are getting ordinary shares, are there any other classes of shares in the company? So if you are investing in a round where maybe a VC is involved, then they might be getting a different class of shares. And then you'll want to look at what are the rights that are attaching to the different classes, and that's typically going to be at the very top of your term sheet. And then next one tends to be information rights. That's always a key one for investors. So as shareholders in a company and minority shareholders, you actually have very limited rights to information under the Companies Act. You're just entitled to annual accounts. And so obviously that's not going to be enough if you've just put some money in and you've invested in the company. So you're going to want to look at what information rights you're getting, and is that sufficient for you to monitor your investment? So that could be different depending on the type of business, and there's a balance to be struck really between how often and how much information you want, versus you don't want the founders to spend all their time reporting to you. So so a balance has to be struck between the information that you need to monitor your investment versus not taking too much time away from the business. But for founders, it can actually be a helpful exercise to if it's, say, a quarterly report to investors, to sort of think, okay, well, what have we achieved over this quarter, and is there anywhere that I can where I could ask investors for help, and this is kind of the opportunity to do that. So
I think it's particularly important if you've got lots of investors, lots of individuals, and different people. It's a good way of managing them and kind of pointing people in the direction where you need support and things. So
yeah, exactly. And I'm sure I don't know if you have your sort of minimum information rights that you tend to look out for, or sort of how regularly you want feedback from the company. But we tend to sort of say as a starting point some sort of quarterly reporting and some financial information as well.
It tends to vary from company to company. So ones that are doing lots of small transactions, you probably want to see more frequent reports, and we'll negotiate it on a deal by deal basis, but vitally important.
Yeah. So the next one on the list is consent matters. So as as a minority shareholder in the company, you're not going to be expecting to have necessarily representation on the board. Sometimes there are, there is, if you've got a large investor or you've got a VC, then they'll have, say, an investor director, but that's, you're not necessarily going to have that sort of representation or control. And so often a key protection for minority investors is consent matters. And again, it's all about creating that balance between what the investor needs to protect their investment versus, not hampering the running of the company. So consent matters are, tend to be a list of matters where the board has to go to the investors for approval before they can carry out those things, and that tends to be the bigger decisions that could go to the value of your investment. So for example, if the company was going to take on debt over a certain level or sell off key assets, for example, but you don't want it to be such an extensive list that the board's having to come to you every week for approval for something. So as I say, a kind of balance needs to be struck there with the consent matters, but it is important to have them there. And some key things to think about with consent matters is that list of matters, and also that they're investor consent matters rather than shareholder consent matters, because obviously at an earlier stage company, the founders probably still have quite a large percentage shareholding, so you want to make sure that it's actually the investors they're needing to come to approval for rather than just shareholders. And you want to look out for really if there's any what's known as deemed consent provisions, which is essentially if you're deemed to agree if you haven't replied within a certain amount of time. And again, it's all about the balance. So a deemed consent matter could actually be helpful for the company, and as an investor you don't want the company to be blocked from the business just because people aren't replying to these consent matters. But similarly, if there is a deemed consent provision in there, be aware of it and make sure that you're responding within the time limits if you need to. So next one is preemption rights, and I'm sure these sound quite familiar to everyone, but this is essentially just firstly preemption rights on allotment. So before the company can issue more shares, that they're offered to the existing shareholders first in proportion to your shareholding. And this is essentially just making sure that you have a right to obviously invest more money so you're not diluted. And then also preemption rights on transfer. So that's before a shareholder transfers their shares, again, they're offered to the existing shareholders first. Again, these are sort of typical mechanisms that we'd expect to see, and for investors it's just you want to make sure as well in terms of the preemption rights on transfer that there's some carve-outs there for what's known as permitted transfers. So transfers if you want to sort of family and interfamily trusts and things, which is often key for shareholders in terms of their tax planning, etc. That's a fairly typical one. The next one is leaver provisions. So leaver provisions, I don't want to say it's the sort of slightly more contentious one, but it's the one where maybe there's a bit more debate. But as an investor in a company, you're often investing in the team, and so you'll want to ensure that the founders are tied into the business in that respect. And as founders, you sort of so essentially leaver provisions is circumstances where if an employee leaves the business, they have to offer up their shares for sale. So as a founder you might be thinking, oh well, actually is that something that I want to be putting my shares at risk? But it's, as I say again, it's a balance, and the investors need to know that you're kind of tied in. And sometimes it is actually helpful for founders as well, for example, where there's co-founders involved, because you want to make sure that your other co-founders are tied in as well. But as I say, a balance can be struck, and whether that's time frames over how long these provisions apply, or the number of shares that these provisions apply to, or if there's kind of reverse vesting mechanisms where the number of shares that they apply to decrease over time. And I'm sure you've seen lots of lever provisions. They're sort of they're very standard in kind of lots of investment deals. So it shouldn't be something anyone's scared of, and can always, as I say, reach a point where both parties are kind of happy with the structure of it. Next one is restrictive covenants. I'm sure everyone's sort of familiar with restrictive covenants from an employment perspective, but it's, you know, similar concept where these are sort of non-compete provisions or non-solicitation provisions. And with restrictive covenants, as you know, investors, you want to make sure that, again, it's about you're investing in often the founder team, so you want to make sure that that they're tied into the business and that there's some sort of consequences should they leave in terms of, you know, them not being able to compete, etc. But what you want to look out for with this one as investors is that they don't apply to you as investors, because obviously you're not working in the business, so they shouldn't apply to you, and also you don't want to then, if they did apply to you, inadvertently breach them, for example, because you know, as a non-compete, as an example, you know, if you're if you've invested in a company and that's an area that you're kind of interested in, you might be making investments into other similar companies, so you don't want to inadvertently breach a non-compete.
Or I mean, we have seen that, and yeah, you know, you're then prevented from working from companies in the same area and stuff like that. I think,
yeah,
you know, that's something you need to get the focus a bit more narrow.
Yeah, exactly, because they're often drafted quite widely, where it's not, you know, it's not just about working in a business, but it's kind of any sometimes indirect involvement with a business. So that's definitely something to be careful for and look out for. But, you know, from the company's perspective, investors will be signing confidentiality. There will be confidentiality provisions, for example, in the investment documents. So from that perspective, in terms of protecting commercially sensitive information, then the company is still protected. Next one is drag and tag rights. So this is where a drag right is where if the majority of shareholders want to sell their shares, then they can drag the rest of the minority shareholders into that sale with them. And then the opposite side of that is a tag right, which is essentially if the majority of shareholders want to sell their shares, then the minorities can tag along and ensure that offer is extended to them as well. And again, you know, for investors, although you might be the minority, you'll still want to see these concepts in there and see a drag right in there, because if there was an opportunity for a sale, you want to be able to ensure that the company can exit if it's the right deal and the majority of shareholders are agreeing to it. And then finally, last one on the list is warranties. And warranties are essentially statements about the business that are given by the company and sometimes also the founders on completion on completion of your investment. And this really and then if one of those warranties proves to be incorrect, you could bring a breach of warranty claim. Hopefully you're not going to be bringing a claim against the company that you've just invested in. So actually often the warranty process in an investment scenario is more to supplement your due diligence, because it can sort of garner information, and also you can have some more. The warranties tend to be around those, you know, firstly the key areas of the company and the business, but also you could have some warranties in there, for example, around EIS eligibility in respect of the company. So that's a very brief whistle-stop tour as to all the kind of key terms that you'd expect to see in a term sheet. And as I say, often it's all about creating that balance between the protections that the investor needs, but not hampering the sort of day-to-day running of the business, because ultimately you want the founders to be doing that so you can get a return on your investment.
Okay, so we've agreed our terms. The investment is now moving ahead. What are the other legal documents we should expect to see, and when do they happen?
Yeah. So I'm going to move on to my my next slide. Um, so once you've got your term sheet, the everything that's sort of set out in there is what's going to form. It'll either go into the Article of Association, which is the constitution of the company and is a public document which is filed at Companies House, or into the shareholders agreement, sometimes called an investment agreement, sometimes called a subscription and shareholders agreement. So those key terms will all be set out in either of those two documents, and the shareholders agreement is the private document that each of the shareholders signs up to. If it's actually the company's sort of first main round, it's the first time they're putting these documents in place, then you'll be signing the shareholders agreement. Or if there's already these documents in place, so you're coming in on a follow-on round, then you might be signing a deed of adherence to the shareholders agreement, which is essentially saying I'm adhering to the document that's already in place. And the key thing for that is making sure you've actually seen the document that you're saying you're adhering to, but you'd just be signing the deed of adherence instead. And then sometimes you'll have a subscription letter, and then the other key kind of document is the cap table, which is always helpful to have a look at, because to see that the cap table sets out who the shareholders are in the company and what everyone's percentage is and what everyone's shareholding is and what class of shares they're holding. So that's always helpful to see, what percentage, say the founders of the company, the founders still have, what percentage sitting with investors, etc. And also on the cap table, you'd expect to see the fully diluted position as well. So if a company's issued any options, convertible loan notes, etc., what everyone's percentages would be should those convert as well. So those are the key documents you tend to see. And I suppose in terms of timings, as I say, term sheet tends to be right at the beginning, and then the lawyers will go away and draft these longer form documents based on what was set out in that term sheet. So the longer form documents do tend to come a bit later in the process. Hopefully they've been prepared on the basis of what was set out in the term sheet. But there'll always sometimes be a bit of back and forth and in terms of drafts of those between the sets of lawyers. I think key tip for you, if maybe you're not the lead investor in the process, is making sure you see those documents as soon as possible, because what you don't want is the lead investor negotiating them and the day before you're due to complete, them sending you these documents to take a look at and read, because that's not giving you enough time really. So making sure that you see, maybe not the first draft, but at least sort of a well progressed draft that you can take a look at, and then when you do get that final draft, you can just be looking at a comparison to see what the changes were between an earlier version that you saw, because especially when there's lots of investors in a round, that does tend to happen sometimes, where the lead investors negotiated the documents and then documents are sent out to everyone else last minute as a sort of, well, here they are then, and we want to complete ASAP.
Yeah, and then what can be helpful then is if someone, probably the founder, kind of summarizes the key changes so that we can just see quickly and just check that they're acceptable.
Yeah, exactly. And that's also why it's kind of going back to it again, why the term sheet's so important, because actually that's something that if the long form documents are prepared on the basis of the term sheet, then what are those key terms that are in there that you need to be looking out for.
Okay, I mean, we use Companies House quite routinely when we're screening companies, just to check who the actual directors are, and also shareholders and shares in issue and things like that. And I always suggest investors follow their portfolio companies. How useful is that?
Yeah, I mean, Companies House is useful. I use it every single day as well. But I always say that take the information at Companies House with a slight pinch of salt, because firstly, it's historic information. It's only accurate, hopefully, as it when it was delivered to Companies House. But also, it's not like Companies House are checking that information. So actually, the information that's on there is just what's been provided to Companies House. So it's definitely helpful. Looking at, as you say, the confirmation statements to see who the shareholders are. Looking at SHO1 filings, which is the form that a company has to file after they've issued shares, can be helpful to see what their last raise was and what the share price was on that raise, for example. And looking at most recent accounts, which are available at Companies House, and as you say, who the most recent directors are, who the persons with significant control are, so if there's charges as well registered. So it's all definitely helpful information. I just it's just that kind of consciousness that it hasn't been sort of verified by a third party. So, and sometimes people do inadvertently make incorrect filings. They might file a confirmation statement saying, oh, there's been no change this year, but actually there has been. So sometimes it does need to be checked against the original registers, or and that's when your due diligence, or when your warranties are helpful. But as a starting point, it's definitely a good way to get a snapshot about a company.
Brilliant, thank you. And then just back to process a bit, when do we send our money? Is that when we sign the documents, or something different?
Yeah, so we would always say you should be sending your money kind of when the round's closing at completion. So you sign your documents, it completes, and you send your money, and then when the company receives the money, it issues the shares. And you just want to be careful that you're not sending your money too early in the process, that it's sort of then inadvertently been treated as a loan, because it's sort of sitting with the company waiting for completion to happen. So yeah, in terms of process, when documents are sent out for signature, this completion is happening, that's the time that you'd be sending your money.
Okay, so we need some sort of assurance that most, if not all, of the money is in place before we send ours.
Yeah, exactly.
That makes a lot of sense.
And actually, some VCs always like to be the last one to send their money, so they won't send their money until everyone else is in place.
Of course. So these legal documents, when you look at them all in one go, they do look long and daunting. What are your tips for reviewing them?
Unfortunately, I think my first tip is you do actually have to read them, which is probably sort of the boring part of it. Well, not to me anyway, but really, it's kind of, the more you do it, the more familiar it becomes to you, and then the easier it's going to become. And also, I think that's the advantage of being part of a network like Angel Academe, is you can lean on people who are maybe more experienced investors. So if you do read the agreements and you're like, oh, I don't understand what this means, ask someone. You could ask us, you could ask one of the other angel investors, you could even ask the company. But I think it's the more you do it, the more familiar it will be, and then the easier it will become.
Right, okay. And just one last question from me. We've got a whole bunch coming in over chat.
Oh gosh.
what are your key takeaways then?
So I think the main one really is know what you're signing up to, and unfortunately that goes back to the reading the documents and familiarizing yourself with them, because with these documents, ultimately it is, if hopefully it's not the case, but if something does go wrong, this is where your protections are. And then I think my other tip is sort of, it's always about balance. So creating that balance, as I said earlier, between protections that you needed as an investor versus not being so restrictive that it's kind of hampering the running of the company.
Okay, all right. Well, just do you want to end
I'll
your
stop. Yeah, I'll stop.
share now? We'll
Stop share.
move
There we
on
go.
to the audience questions. So, good question from Crisula about how can we influence the terms as angels? And if you don't mind, I was just going to get in there with a couple of points first. And I think the main thing is that the earlier you're investing, probably the more influence you have, because there won't have been a previous term sheet and legal documents from previous rounds. And also as an angel investor, the more your investment will get you in terms of a percentage ownership. So being involved earlier on will give us more influence of that, and also having a good relationship with the founder so they trust us that, you know, we're aiming for that balance as you talked about. But is there anything else we can
I completely agree with that, because you know, if you're investing it around when these documents are being put in place the first time, it's easier to negotiate them. It's a lot harder when you're being sent the documents that are already in place and a deed of adherence to kind of go back and try and unpick what, you know, what other investors have been willing to sign up to. So definitely, kind of, if you're one of the earlier investors, then you're going to have more influence. And as you say, if you're depending on how much you're investing as well, you might have a different influence. And that's again why sort of investing as part of a network is helpful, because as a group together you're going to have a bigger shareholding and a bigger sway and more influence in the documents. As you say, sort of having a good relationship with the founder, and also that's why, going back to the information rights, if it's set out, well, actually the founders have to provide you with this, then you know that you're going to be getting some regular information. You're not having to badger them, which is then not going to create a good relationship with them.
I think in an ideal world, yes, that's absolutely right. But this is a follow-up question for Crisula. I mean, those of us who've got lots of investments, you do sadly find that there's always a small number of founders that aren't as diligent on sharing information rights, regardless of what they've signed up to, and especially financial information and things. Is there any way? What can we do, if anything?
Well, I think that the thing with that is, well, as long as if it's in the documents and you've got it written down that they do have to send you, you know, certain information, then sometimes you do have to be the bad guy and wait, you know, get that shareholders agreement out of the drawer and wave it at them, saying, no, you've agreed to this. And, you know, ultimately, if they're not following what they agreed to do in the shareholders agreement, then that's a breach of contract, and technically you could bring a claim. So that's sometimes the sort of the threat of that can be helpful, but that's why having it in the agreement, so you can point to something and say, no, you need to be doing this, is what's helpful. But then I think it's, you know, going back to what we talked about before, sometimes it's showing them that actually it's an opportunity for them to you know, get the support and help potentially that they need from the investors. And not communicating with you isn't that they might not get that help, or you know, thinking about it completely selfishly, when it comes to raising their next round, you might be less inclined to follow on with your investment if they haven't been open with you about that kind of information.
We've got one founder who's particularly good at reporting, and she, you know, her mantra is she doesn't want any surprises. So, you know, the path of high growth entrepreneurship isn't always, it's more like that. So, you know, you know, her view is if people are ready for the bad news, they've been prepared for it, they will still be supportive. And that's certainly my experience. You know, investors are much more likely to follow on, even when, you know, things haven't gone smoothly with the business, if you've kept them informed, if you've treated them with a bit of respect, basically.
And I think especially, you know, if it comes to funding as well, you know, if rather than it just being that shock of, oh no, actually we need more money. If the investors have been able to see that in your reporting, then it's going to become less. It's going to be less of a shock. And also, it's something that they're ultimately going to have to get used to as well. And it's a good habit to be in, because when you get to the VC investor level, there's going to be a lot more reporting, a lot more stringent.
You think we're nosy, don't they?
Exactly, yeah. And so actually it's good habit.
Yeah.
And then you've got all of the information there ready for you when you're going to your next raise or something like that. And it's a lot easier to send out a quarterly report than have questions from 15 different people every now and again.
Well, exactly. So slightly different area to talk about. Galina has asked about reverse vesting for founders. Is that standard, or is it just mainly used at very early stage companies? Might be worth saying what reverse vesting is.
Yeah, so reverse vesting, this comes back to what we talked about in terms of leaver provisions. So reverse vesting is essentially where you're saying that the shares are that are at risk of being subject to these leaver provisions reduces over time. So on say day one after the investment, you might have most or the majority of the shares subject to the leaver provisions, and then that reduces over time, which is why it's called reverse vesting. It's common at all stages, really, and it's sort of going back to what I talked about in terms of striking that balance between the investors having the protections that they want versus the founders thinking, well, these are my shares and I founded the business and I don't want them at risk. And so it's that balance, and reverse vesting is one way which is sometimes more palatable to do, because it's got that reverse vesting over time. So you've got the shares that are at risk are reducing over time, rather than saying, well, all of your shares are subject to leaver provisions. So reverse vesting is a very, very common mechanism that's used to do that.
Okay, and then a question on warranties from Chrysula again. Warranties often seem to be missing. What can we do if we think they need to be in there?
Yeah, so I think again, this goes back to depending on what round you're investing in as well. So if the documents are already in place, then there might have been warranties given at the time that previous investment was done. And then if you're investing now and signing a deed of adherence, then you might have a subscription letter and have your warranties in that, or a short subscription agreement and have your warranties there. If there's sort of no mention of warranties at all, then, as I say, it's something to ask for. If it's a very early stage company, then it might be a very short set of warranties, because we've done some raises where it's an early stage company and it's essentially just an idea that of the founder that some investors are investing, so there's nothing there yet. So it was a very short set of warranties, but it's definitely something to ask for, and it's something that can go into the documents, and it doesn't have to be they can be tailored depending on the stage of the company. So it doesn't have to be a 15-page set of warranties that might scare some founders off. It can be sensible and tailored for the stage of the business and the type of business as well. And often they can be drafted as, say, negative warranties that don't warrant disclosure. So for example, the company's not involved in any litigation. You don't have to, as long as there's no litigation, you don't have to disclose against that. So yeah, I think it's, if they're not there, something to ask for. And that's a key one actually to think about, is if you're a later stage and documents are already in place, putting the warranties in a subscription agreement or subscription letter.
Okay, and then so just if you can't get kind of agreement amongst all the other investors are happy to sign, but there's something that you still think is missing,
Yeah.
Occasionally we put that in a side letter that will apply just exclusively to Angel Academe, because it's something that's more important to us than the other investors, rather than the entrepreneur having to get everyone to sign new documents.
Side letters are used. I mean, you want to make sure that it's drafted properly so it is legally binding, it's got all the clauses in it that you need. Side letters, again, are sort of, we come across them a bit more, say, where documents are already in place, but as an example, if it was, say, information rights that you felt were important, then but they weren't already in the documents, then rather having to amend all of the existing documents, you deal with it in a side letter, and maybe in a future round where documents are being updated, because they will change when maybe on a later round when a big VC say comes in, then it can be picked up then. I think the only thing about side letters is and this is sort of sometimes more from the founder and company perspective having to manage, is you don't want to have loads of side letters saying lots of different things with lots of different investors. So it's just making sure as well from the founder's perspective that they're treating investors equally as well. Obviously, if it's a scenario where none of the other investors, if they're aware of it and don't really mind, then that's fine. But that's just something to think about. And also, that's probably a good due diligence question as well. You know, other than the shareholders agreement, have you entered into any side letters with other investors?
Okay, so there's a question here from Laura, and Laura is also a lawyer, and she says, many thanks, this is such a great summary, so well done. She's saying, in startup scenarios, one thing I've seen a few times is that the founders may have done quite a bit of work prior to incorporation, and it's only when a live investor scenario arises that they have to start to organize themselves. How common is it to see terms in the foundational documents which essentially force the company to tidy up prior activity, for example, getting rights to tech or development, so contracts and things like that?
Yeah, I mean, that's always, when we're acting on the company side, it's always one of our first questions is, you know, is any, it typically tends to be around IP, you know, or development. Somebody started to do something prior to the company being incorporated. And that's always one of the tidy up points, is making sure that deeds of assignment of IP have been signed by the relevant people. So all that IP is invested in the company, because obviously that's what you as investors are investing in as well. So I think it's definitely it happens a lot, because often people are wanting to see if there's some legs there before they start setting up new companies and things. So it happens a lot. It's making sure that they either have done that tidy up work or are doing it now, and the way that you find out about that is asking the question during the due diligence process, but then also that could be a warranty point. You know, does all of the IP that relates to the business belong to the company and is vested in the company? And that's kind of how it tends to be dealt with, but it is common, so it shouldn't sort of scare you off as investors. It's just making sure that that bit of tidy up work has been done.
Thank you. Right, another change of gear. Question from John is that, do existing investors or potential investors have a right to see the cap table?
Well, in terms of a right to see it, then as I said, as investors, we don't actually have a lot of rights in terms of information. So it's kind of checking whether that's one of the things that's covered by your investor right information rights in the documents, and it would be kind of slightly odd for them not to provide it to you, but if they're saying no, then another way you can find out that information is by looking, as we talked about, at Companies House. As I say, slight pinch of salt, because it's only accurate as when that information was submitted, if they've submitted it accurately, but you can definitely garner a lot of information from there in terms of how many shares are actually in issue, and looking at the latest confirmation statements to see who shareholders are. Obviously, Companies House wouldn't show you things like option schemes or if there are other kind of convertible securities in place, but it gives you a good idea as to well, it will tell you how many shares are in issue.
Okay, and then a good question from Richard. So if the relationship between two co-founders breaks down, what can investors do?
So I suppose there's the sort of relationship management kind of side of it, which often, investors are trusted advisors sometimes, and it's someone that can be coming in as an invested party that can sort of potentially try and mediate that if there is a problem. I suppose hopefully hopefully, if you've got more than one founder in place, that's when, sometimes having a third person on the board, say an independent director, can help, because it helps kind of with the day-to-day running of the company in terms of management, if there then does become issues with founders. And then actually, if there is ultimately an issue where one of them is, say, going to leave, for example, that's when, going back to leaver provisions again, it's helpful to have them in place for not just the investors, but for the other founder as well. Because actually what you don't want is having no leaver provisions in place, one founder exiting and then still holding a big chunk of the percentage of the company.
Yeah. I mean, we've been in that situation quite a few times. Not that founders fall out, but I think what tends to happen is that they have completely different either personal ambitions or ambitions for the company, and one quite often decides to leave, and then yes, the terms that govern how they leave and what happens to their shares are absolutely essential, because any incoming investor might look at them as a blocking shareholder if they still own a big chunk of shares but aren't involved in the business. So to have
exactly.
that defined, it's a sad it's sad that the legals are all about kind of what happens when things go wrong.
But
that we hope will never happen. But
exactly, and that's why I always say, hopefully you don't have to go back and look at these documents, but there are scenarios where if all the right things have been put in there, that then you've got the protections there for you.
So we've got a question from Tashita, going back to information rights. Have you ever seen a breach of contract claim being filed successfully?
Well, often kind of in terms of, because I work in the corporate team, we'll start waiving the shareholders agreement at people and potentially sending some nasty letters, and hopefully then they kind of kick into gear, and we do see them then cooperating. Sometimes just if that's not working from investors themselves, then sometimes it does work if the letter comes from a lawyer. In terms of then kind of if it went then litigious kind of from that perspective, then it would be going to one of our other departments here, like our litigation team. But as I say, often it's kind of just about having that stick and waving it at them a bit to kind of kick them into gear. That does tend to do the job, hopefully.
I think one thing that works quite well with founders, some are paranoid about their information kind of passing into the public domain or to competitors, and they've got some justified concerns around that. But it's if they don't want to kind of publish too much information, a shareholders meeting, a meeting with us. So we've got a couple of businesses where we have monthly update meetings, and everyone can come along and speak to the founders, and that's great for us because that's sort of relationship building, but means we get the information in the detail that we want in a way that the founder's comfortable with.
Yeah,
So
and you know, so I was going to say, and as we talked about kind of earlier, if that is something founders are concerned about, then there will be confidentiality provisions. So you know, you can always say, you know, I'm caught by these confidentiality provisions as well, so it's not like I'm going to be disseminating the information.
So I think I'm just conscious of time,
Oh.
and we are coming to the end of our questions, but last one is from Helen, so another lawyer, but an IP lawyer.
Okay.
She's saying, do term sheets or shareholder agreements ever refer to any plans for the business, i.e. the company will be in the business of X, not in the business of Y?
Yeah, so typically the business of the company is defined in the shareholders agreement, and sometimes one of the consent matters, which we talked about earlier, will be, you know, changing the business, defined term business of the company, and then also sometimes the specific business plan. It's not necessarily appended to the agreement, but there are provisions in the agreement about, you know, the business plan being reviewed annually and provided to the investors, and you know, material changes to the business plan being a consent matter as well. So yeah, there's usually provisions in the agreements around what about the business and not changing the business.
Sorry, she's also mentioned, you know, is that the place to kind of include your intention to keep compliant with EIS or SEIS?
Yeah, so in terms of EIS and SEIS, you know, as we kind of all know, there's a few different elements to that. It's not just the company eligibility, it's also your individual eligibility as well. I mean, in terms of what's in the company's control, the company being eligible, then there's often, as I said, there's sort of warranties around the company's eligibility as an EIS company, and then often there can be undertakings in the agreement that they're not going to do anything to they'll use reasonable endeavours not to do anything to jeopardize that eligibility as well. So you'll often see provisions around that in the documents too.
Okay, Emer, we will leave it from there today. I think we could do a whole other session on it. Quite a lot to take in. Thank you so much for your time and insights. I've just got one more slide to run through about next steps for people who are in the audience. So if you're a founder currently looking to raise investment, then please have a look at our investment criteria and apply to pitch to us. It's a simple online form. If you'd like to join us as an angel investor, we'd love to have you. Please contact Michelle and follow us. We've got a monthly newsletter. We're quite active on LinkedIn. All the recordings of our previous sessions like this are on our YouTube channel, and we've also got a Medium blog. So thank you very much for joining us. I'm sorry about coughing into the microphone. I hope it wasn't too disturbing for you. Enjoy the rest of your evening, and I hope to see you soon. Thank you very much.
Bye.
Bye, everyone.